Roads in decentralized law. Roads are necessary for passage on land, and may have practical use forever, even with the advent of more air transportation technologies, or sci-fi wonders like teleportation. Roads are easements to property, and without easements, there cannot be access to property, which renders it unusable, but property being key to the philosophy of individual freedom and ownership of self, easement must be just as strongly protected as person or property, since it is equally important in terms of living in freedom. Easement to property is essential for human freedom, not optional. Easement is not a small issue in the topic of civilized, moral living, or the living standards required for lasting peace and prosperity, but is absolutely foundational. Obstruction of easement, or threat against use of easement, at any time, must be deemed as criminal aggression and brought to legal judgment for strict reform. Obstructing one's passage is the same as detaining them, which is aggression, a violation of the standard by which societies must live in order for lasting peace and prosperity. Because it is in the interest of all to protect their right to property and self-ownership, it is only decentralized law that can most assure the universal upholding of fair and based law decisions. Centralized law has used road passage to exercise dominion over others for thousands of years. Selectively screening who may pass and who may not is a violation of individual freedom and prone to great abuse. It must be assumed that most or all have an invitation or right to arrive, or are themselves property owners. It is true that unwanted customers, shoplifters, those under a type of restraining order, and other unwanted guests can rightfully be denied access to a property by rightful property owners or tenants, and that this type of screening can potentially be integrated into roadway restriction, either technologically or otherwise, as a service to rightful owners and tenants, but the restriction by central control, such as governments, gangs, or cartels, to restrict trade routes, extract fees, tariffs or taxes, or otherwise control the flow of travel and access to property, is violating the basic right to easement foundational to human freedom and required for lasting peace and prosperity. We do not know what technologies may come, such as science fiction concepts like teleportation, but what we do know is that roads are crucial at this stage in our technological development, and are therefore still necessary for property access. Some property theories include ownership of all space above the property, and in the ground below it, which means that the airspace above is deemed part of the property, and overhead flight of another without permission would be considered trespass. This may prove to be increasingly important to people as more and more flying machines become available and affordable. Airspace trespass may be of increasing concern for some as technologies advance. This theory of property ownership above the property may establish limitation by restricting flight to airspace directly above roadways, at least for low-flying aircraft. Low-flying aircraft may have less chance to deploy parachute or other safety feature than higher-altitude flyers, which may guide preference toward them flying only above roads or special lanes for overhead flight. Because flight has huge potential for easing up on road traffic, and for convenient and swift travel, it may be the generally accepted practice to allow one another overhead flight on property if above a certain altitude. This would allow the various flight paths in use today, as well as other possible flight paths. Law regarding flight path and ownership of airspace above property is just one topic of many that must be taken from central planners and given direct democracy or open source law formation and agreement, which is decentralized, and its evolution would be collaborative by the masses rather than by those claiming to represent the masses. Some roads, though not all, are easements to property, and the access of these easement roadways would be protected by decentralized law, in the branch of private property and real estate theory. Easement is the right to access a property, and without easement, the private property is of no use, which makes universal regard for easement law an essential portion of private property rights. Without easement, private property is not owned. If a road is established as an easement to a property, it must remain so even forever. The owner of the road cannot alter or restrict easement. This is a servient form of ownership. Easement is embedded into the principles of non-aggression and self-ownership. To own self, you must have option to own land and resources to sustain self and build your life as you see fit. Private property must have easement because the easement is how you get to your property, and it must not be obstructed or limited by another in any way for any reason at any time. It is not the right of a road owner to charge tax, or fees by any other name, in exchange for access, if the road has been legally established as an easement. An unimproved path can be improved through voluntary agreements. All expenses to upkeep a road must be acquired without the use of force, and without threat to easement. Decentralized law must uphold this standard, as it greatly affects the non-aggression standard, which greatly affects quality of life. In decentralized law, there is great limit on attempts to gain power through the control of roads, because of all of the other dynamics of free market services, including reputation and financial recourse, as well as actionable defense of rights by others, law service providers or otherwise. In other words, any attempt to rule through monopoly would cause some repercussions in reputation, which would serve as a disincentive to continue such behavior, and would compel opposition to block the attempts to control. People who have become acclimated to the environment of freedom are uninclined to allow dominion. Real estate law being a branch of law services that dives into the philosophy and practice of protecting mutual property rights, it is the branch of law that holds the easement to property in the same esteem as the property itself. If one has not easement to property, the property is not accessible and is therefore not usable. This branch of law ties in heavily to the subject of roadway usage rights. The universality of rights, meaning that if one has rights, all have the same, is imperative to sustainable freedom. For example, governments claim the right to tax, and this tax is the forceful removal of assets, which is theft. If forceful removal of assets by one party is valid, why is it not valid for all others? There has to be a basis for such a right, which there is not, and if there were such basis, it must be mutual, and therefore money taken mutually would cancel out the usefulness, being gainful to none. Similarly, real estate law would, as it already does, deal with the universal right of easement to property, which includes the making of decisions about how to ensure property owners and their guests can access their property. This right must be universal, just as self-ownership is universal, because it is part of self-ownership, a very important part that allows private ownership of property. One may choose to strategically arrange the purchase of strips of land that form a road, and this road may be useful in accessing property without the owner ever establishing the road as an easement, which means that there is no restriction on the owner in terms of charging fees and limiting access. Yet the inclination for the public to use such a road is substantially different from their inclination to use established easement roadways. The existence of both options would ultimately make efficient access more possible and provide more options to motorists. Laws would form regarding the conspicuous labeling of the type of road right at the start, ensuring clear communication to users before entering the road. What cannot be reasoned is the requirement for a road owner to maintain a roadway. Restricting access is not permissible, but neither is forcing a road owner to maintain a roadway. A road owner may have incentive to keep the road well maintained, to keep it plowed, to remove rock slides, mudslides or fallen trees, repair or replace bridges, and other tasks, but such cannot be required. Instead, what must be required is the permitting of repair or maintenance by any person or group stepping forward with funding and plan, if even not optimal or a long-term solution. If the repair or maintenance is the best option presented to ensure access to property in the immediate future, it must be applied. What makes these desperate funding measures less likely to be relevant is the business model of roadway advertising, pit stop commerce lanes, or the rental of spaces directly on outer lanes of the roadway for quick drive-through commerce, and many other entrepreneurial creations made possible by the unthwarted, unhindered, unrestricted innovation environment of decentralized law. Road owners would be competing in not only the quality of their commercial offerings, but also the quality and safety of their roads. Road entrances and exits, as well as intersections and overpasses and underpasses, would come with organically formed, open source rules. If a road owner is asked by another road owner to allow an intersection of his new road, perhaps creating a mutually beneficial opportunity for both owners and motorists, there would have to be limitations on how restrictive one party can be on such requests. If the existing road owner insists that the new road maker must pay the entire cost of the intersection, or if the existing road owner insists that an overpass be built with entrance ramps, instead of an intersection, this can be cost prohibitive to road creation, which can limit it to only massive companies, creating issues in entrepreneurial possibility and issues like road monopoly. Rules for what is fair in the crossing of roadways by two or more owners must be established in an open source fashion, which is law created by the masses, rather than those who claim to represent the masses. This is a form of direct democracy, a significant upgrade from representative democracy. Democracy being generally an evil if left unguided by sound principles, this formation of law must be coupled with the guiding by principles established as sound through the same process. Road management, security, and maintenance, all having some significant costs, and road rules, laws, and practices, all having some unavoidable complexities, can all be smoothly operated under the free market in decentralized law. Decentralized law imposes reasoned thinking onto everyone, which would drastically change society from what it is now.